Welcome back, everybody, to the Law of Tort. In this lesson, we're going to introduce the next of our major topics, which is, of course, looking at the first major tort for this series, the tort of negligence. Now, we're going to take an introduction to the subject of negligence in this lesson before unpacking the first key component of negligence in the next lesson, which is, of course, the duty of care. So, we're going to examine three major issues in this lesson when we talk about the tort of negligence. We're going to ask the question of what negligence actually is. Can we come up with a clear, delineated, and descriptive definition of what negligence actually is? What is the equation of negligence? What are the key components that are required to show a negligence, or to at least have a successful negligence claim? And then the final point is, why is negligence so important? This is going to be able to provide for you a basic overview to the subject of negligence, to the key components of negligence, as well as the impact and importance that negligence has in the law of tort to this day. So, essentially, for any law student that is studying law in the UK, specifically also within the jurisdiction of England and Wales, you will have to study the law of tort. It is a foundational topic. It is a core module. Whether or not you are doing an LLB, whether or not you are doing A-level law, or whether or not you are doing a conversion course, whether that be the GDL or the SQE, you will have to study the law of tort. In addition to this, you will also have to study the tort of negligence. It is the most important tort for any law student. One of the reasons for this is, of course, the frequent use in litigation. If you ever operate and practice law within the jurisdiction of England and Wales or within the UK, and you practice the law of tort, you will often be doing negligence. In fact, people tend to, or at least law firms tend to specialize not necessarily in the law of tort, but they will specialize in specifically negligence claims or specifically defamation claims. And so as a result of this, the tort of negligence is very, very important. This wasn't always the case, however. The tort of negligence and its frequent use in litigation was not actually always the case. In fact, the tort of negligence is something which has developed into a unique set of complex and flexible rules, and that these complex and flexible rules, this sort of development of negligence, only really takes place in the latter part of the 20th century. And it almost entirely takes place through the common law and the development of common law decision-making by the judiciary. So as a result of this, the tort of negligence is going to require you to have a deep and in-depth understanding of various different cases, which we will get to in future lessons' time, as well as the development of those different cases and the development of the expansion of the tort of negligence, as well as in some cases a contraction of the tort of negligence as well. So we'll get to all of that in future lessons, but for now let's just work out a definition of negligence. Let's work out how we can actually define what negligence is. And a useful definition we can find is in Giliker from 2023, and also from previous editions as well. I have two editions of Giliker, the 2023 one and the 2017 one. And they both have this same definition, and this is a definition of negligence, which is essentially that they say that negligence is a breach of a legal duty to take reasonable care that results in damage to the claimant. That is what is defined as negligence, and it's a particularly nice definition of negligence. It's you could have different definitions, but ultimately what this definition does is give us what negligence is, because what it does is it unpacks for us, or at least we can unpack from this definition, the various different elements which are required to show and to have a successful negligence claim. And these refer to what are described as the equation of negligence. So let's just read this definition again. It's very short, and let's see if we can pick out the key elements which exist within this particular definition, which essentially are the key requirements for a successful claim of negligence. So it says that negligence is a breach of a legal duty to take reasonable care that results in damage to the claimant. So the idea of there being damage to the claimant is something that exists within the vast majority of torts, within all torts, because we're talking about claim compensation for wrongs, compensation for damage. But the beginning here is a breach of a legal duty to take reasonable care. This here encompasses two fundamental elements, and the first two elements of the equation of negligence. The legal duty to take reasonable care is the first element of negligence, is the first requirement. You need to show, if you are going to try and have a successful negligence claim, that there was a legal duty of care. There was a duty to take reasonable care in a particular circumstance owing to the facts of a particular case. The next part of the equation is the breach of that duty of care. So not only do you have to identify that there was a duty of care, but that that duty of care was breached. And that then we move on to the third of those major requirements. And this is the resulting in damage. Okay, so we have to show that there is a duty of care. We have to show that that duty of care was breached. And then we have to show that the breaching of that duty of care causes damage. We have to have causation here, and that leads to the equation of negligence. So this is what we have. We have to have a duty of care. We have to show that that duty of care was breached, and we have to show that that breach caused the damage in question, which then therefore results in the potential for a successful claim in negligence. That is what we need to show. And these are the three component parts of negligence that we're going to look at. We're going to begin by talking about the duty of care. We will then talk about all the different elements and theories and ideas within that particular context. We will then move on to the idea of a breach of a duty of care, looking at the standard of care, the way in which the standard of care is applied, the reasonable person test, etc., etc. And then we will spend a lot of time looking at causation, talking about how causation is operational, looking at the various different intervening causes that could exist, the idea of remoteness as well, and then all of this comes together to form a successful claim of negligence. So essentially, that is what we have. We have to have a duty of care to the claimant, a duty to take reasonable care. That particular duty must then be breached by the defendant, and then the breaching of said duty must have causally led to the damage in question. And then those all together contribute to a successful claim of negligence. The final thing I want to note is that we have a look here at the distinction between negligence and intentionality. Because one of the most important things that we can know about the tort of negligence is that it doesn't necessarily imply that the defendant had acted intentionally in their conduct. In fact, it actually implies the opposite of that, that it was not intentional, that negligence was something that was relating to things like carelessness. It was a careless breach of a duty of care, which then therefore leads to the harm in question. And so this means that negligence does not assume intent, nor does it require intent for the liability to be found. A person doesn't need to intentionally have caused harm to a claimant in order to find a case of negligence. Intent is actually irrelevant. For the most part, claims of negligence will be accidental. We will get to having a look at different claims of negligence in future lessons, but it is for the most part accidental, carelessness, and general incompetence in some cases as well. And that's what's important to note, that negligence is not intentional. It is something that does not assume nor require intent for there to be the showing or the requirement of liability. In the previous lesson, we took an introduction to the tort of negligence. We explained essentially what the key characteristics are when it comes to determining whether or not negligence existed or whether or not an individual can be found liable for their negligence. And we noted quite interestingly that the key components of negligence include a duty of care, a breach of said duty, and then the action or omission in some circumstances to lead in causation to the harm in question. Now, this lesson is going to start unpacking the first of these major elements, which is this idea of a duty of care. So we will be taking an introduction, if you will, to the subject of a duty of care within the broader context of the subject of the tort of negligence. We'll be spending the majority of this case arguing and looking at an examination of what is arguably the most famous case in all of English law, which is the case of Donahue and Stevenson. and we'll explain why this case is so important for the principles of the duty of care that it enshrined, and we'll also take a little stroll down the facts of this case as well, for those of you who don't know it, but I would be surprised if anybody who's watching this video does not know about the facts of the case of Donahue and Stevenson. So, when it comes to the duty of care and an examination of how the duty of care develops within the law of tort from a historical perspective, we can actually see that it begins its life as quite a limited doctrine, as quite a limited principle, because it was only really limited to contractual relationships. And so as a result of which, you have a legal duty to take care, but this legal duty to take care only arises in circumstances where the individuals in question are under a contractual obligation, and so this legal duty exists only through this contractual obligation. Now, the scope and reach of the duty of care would be challenged in this regard in the case, one of the most famous cases in English law, the case of Donahue and Stevenson, because what arose were facts which would suggest that a duty of care probably ought to exist, but that there wasn't a contractual relationship between the defendant and the claimant in this regard. So how can we either reject the claimant's arguments and reject the claim that was being issued, therefore maintaining this quite limited contractual understanding of the duty of care, or alternatively adjusting this concept of the duty of care to extend beyond that of mere contractual relationships? So that's really what we talk about in the case of Donahue and Stevenson. Let's begin by thinking about the facts of this case. The facts involve a Mrs. Donahue and one of her friends who allegedly visit a cafe by the name of Minchella. Now, one of the things that's important to note here is that the facts of this case were never actually challenged in the kind of way that you would in an actual case. Because the legal issues of the duty of care and all these different things went straight up and appealed up to the House of Lords. So what's quite interesting is the actual facts were never proven as to whether or not this happened. So we're going to say that these are the alleged facts which take place. We're just going to assume that they are true for the purposes of this series of lessons. So we have Mrs. Donahue and one of her friends visiting a cafe by the name of Minchella. At the cafe, the friend of Mrs. Donahue would purchase for her a ginger beer float, which is a type of drink, essentially. And this ginger beer float would actually arrive in an opaque bottle. That is also something that is important to note. Make it very clear, look, that what we're talking about here is a bottle that was bought by the friend of Mrs. Donahue and then given to her. So she was the one who made the purchase. Mrs. Donahue would then drink some of the ginger beer before her friend discovered, upon topping the drink and tipping out the insides of the drink, that what was inside the bottle was the remains of a decomposing snail. Obviously, Mrs. Donahue isn't particularly happy about this set of affairs. She's drank some of the ginger beer, of which there was a decomposing snail within it, and upon seeing the snail, knowing that she had drank from that, it had made her ill. Okay? So these are the facts of this case. The issue for litigation in this case was who could Mrs. Donahue sue? Because if we think about the limited duty of care that existed previously within contractual relationships, well, Mrs. Donahue didn't have any contractual relationship with Minchella, with the people who ran the cafe, because the bottle was bought by her friend, not Mrs. Donahue. So there was no claim there. In addition to this, Minchella didn't have any liability because there was no duty of care in the fact that they had received the opaque bottles already sealed and was in the process of didn't make any final extra checks, and it would have been impossible for them to make any extra checks as to the contents of each of the bottle anyway. So instead, Mrs. Donahue made the decision to sue the manufacturer of the bottle. And in addition to this, the retailer, like I just said, could not have been at fault because they were unable to check and see the contents of the bottle themselves. It was an opaque bottle. So Mrs. Donahue would go on to sue the manufacturer, who obviously didn't have a contractual relationship with Mrs. Donahue. We have sort of two levels removed. The manufacturer had a contractual relationship with the retailer, presumably, and then the retailer had a contractual relationship with the friend of Mrs. Donahue, but then Mrs. Donahue was given the bottle as a gift or as a purchase for her. And so as a result of which, this idea of Mrs. Donahue making a claim against the manufacturer cannot be done on the basis of a contractual obligation because there didn't exist any contract there. And despite this being the case, she would ultimately win her case against the manufacturer. And this was seemingly relatively innocuous, seen as a relatively innocuous decision made by the House of Lords. However, it was the word of Lord Atkin which enshrines one of the most important principles of the duty of care. And this is known as the neighbour principle. And this is the passage that we can see from which we can find the neighbour principle. They say that the rule that you are to love your neighbour becomes in law, you must not injure your neighbour. And the lawyer's question is, who is my neighbour? Receives a restricted reply. You must take reasonable care to avoid acts or omissions which can reasonably foresee would be likely to injure your neighbour. Who then in law is my neighbour? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called into question. Now, what the neighbour principle does is essentially generalises the principle of the duty of care. No longer is the duty of care very specifically limited to this idea of there being contractual relationships. Well, now the duty of care is generalised. It is now a generalised principle to your quote-unquote neighbour. And so the neighbour principle, as stated on the previous slide, has with it two interesting components. We have this idea of reasonable foreseeability, and then we have this idea of proximity. These two elements of the neighbour principle essentially expands the legal duty of care beyond that which is just contractual relationships. And what we will see in the next lesson is this case essentially being picked up by subsequent cases. And there has been something of an expansion of the legal duty of care, and then a restriction of the legal duty of care, and a sort of reformulation to the point where we have the principles that exist today. So we're going to get into that as we look at the development of this principle of the duty of care in the next few lessons' time.